For most of a decade, almost every automobile built in the United States carried a small brass plate. It said the car was manufactured under the Selden patent. It was in effect a receipt, proof that the maker had paid a toll to a man in Rochester, New York, for the right to build a car at all. George Selden did not run a factory. He had barely built a working automobile. What he had was a single patent and a theory that it covered the entire idea of the gasoline car. For years the industry paid rather than fight him. Then a new company refused. Its name was Ford. Here is what makes the Selden case so strange. The patent was filed in 1879, before the automobile industry existed in any real form. George Selden was a patent attorney, and he understood something most inventors didn't, that a patent's value depends entirely on timing. So he did something deliberate. He kept the application alive but unfinished, amending it, refiling it, stretching the process out for 16 years, until 1895, when motorcars were finally becoming a business worth taxing. Then he let it issue. United States Patent 549160. On paper it described a road vehicle driven by what it called a liquid hydrocarbon engine of the compression type. The wording was broad enough that Selden could argue it covered any car with a gasoline engine, not a specific carburetor, not a specific transmission, the car itself. That was the claim that one man, who had never mass-produced a vehicle, owned the concept of the automobile. And for a while, the law let him act as if he did. In 1899, Selden sold the patent's commercial rights to the Electric Vehicle Company, and in 1903 the major manufacturers organized into the Association of Licensed Automobile Manufacturers, ALAM. The arrangement was simple and lucrative. To build cars legally, a manufacturer joined ALAM and paid a royalty on every vehicle it sold, a fraction of the list price of each car, with a share flowing back to Selden. Most of the industry signed up. It was cheaper and safer than a lawsuit, and membership came with a kind of protection. The licensed makers could point at anyone outside the club as a pirate. Then Henry Ford applied to join, and by the account that came down through the industry, was turned away as a mere assembler. So Ford built cars without a license. ALAM sued the Ford Motor Company in October 1903. Their position was absolute. The Selden patent covered the gasoline automobile. Ford built gasoline automobiles, therefore Ford owed. Ford's position was just as absolute. He argued the patent was a fiction, that Selden had invented nothing the industry actually used, and that you could not tax an entire industry on the strength of a drawing. ALAM ran advertisements warning that anyone who bought an unlicensed car could be sued. Ford answered with his own ads, promising to defend his buyers personally. The fight became the most public patent war America had ever seen, and for years it went the wrong way for Ford. On September 15, 1909, Judge Charles Merrill Hough of the Federal Circuit Court in New York ruled. He found the Selden patent valid and infringed. It was a complete victory for ALAM. As written, the decision meant Ford and every other holdout owed royalties on every car they had ever sold without a license. Ford appealed, and in January 1911 the United States Circuit Court of Appeals for the Second Circuit reversed. But not in the way anyone expected. The appeals court did not throw the patent out. It held that the patent was valid. The trick was in its scope. The judges read Selden's claim narrowly. It covered a car powered by the engine Selden had actually described, the Brayton-type constant pressure design. But Ford's cars, and by then essentially the entire industry, ran on the Otto cycle, the four-stroke engine still in use today. Selden's patent, the court ruled, did not cover the Otto engine at all, so the patent survived and protected nothing. It owned an engine almost no one built, valid and useless in the same sentence. The timing made the victory almost cruel for Selden. The patent was set to expire in 1912, about a year after the ruling. Even if he had won outright, he would have owned the automobile for a few more months, and then lost it to the public domain. Instead he got a narrow patent on a dead engine, just in time for it to die anyway. ALAM dissolved soon after. The toll on the industry ended. Over its life the patent had earned Selden several $100,000. A real fortune for the era, but a rounding error against the industry it had briefly governed. And Ford emerged as something he would never stop being, the man who refused to pay and won. He had not proven the patent worthless. He had proven it was about the wrong engine. He won on scope, the narrowest ground available, and that was enough to free an entire industry. The Kearns file showed a man with a real invention spending his life forcing the law to admit it was his. This file is the mirror image. Selden had almost no machine. What he had was a piece of paper, kept deliberately pending for 16 years so it would surface and tax an industry he never built. That is the whole lesson of this one. A patent does not have to describe something you made, or even something that works. For a while, it only has to describe something other people are afraid to fight. Selden owned the automobile until the day someone read his patent closely enough to see it described a different car. Next time a chemist who patented a way to make rubber out of thin air, and watched a rival file almost the same idea on almost the same day.